It's the largest antitrust case we have seen in the tech space since the government's case against Microsoft. We've heard a lot of comparisons between those two, and I wonder if you think that's a fair comparison. To what extent does the government's case against Microsoft provide a template in this particular one?
Well, it provides a pretty good template. In many cases, in many ways, the cases are quite similar. Microsoft, the case against Microsoft involved a lot of defaults that made Microsoft's property sort of the first thing that consumers saw. Microsoft's operating system, the desktop, Microsoft's browser at the time, Internet Explorer, those things were sort of default options that were given to consumers. And that was a big part of the DOJ's case against Microsoft. And so in the same sense, the Google case, the search dominance case, involves a lot of arguments that Google has, by making its search engine the default option, foreclosed other competitors from being able to take over in that area. So in that sense, these cases are a lot alike. And in fact, if that were all to it, you could say, well, the Google faces, some serious concerns given what happened in the Microsoft case. On the other hand, I think the law has changed in some significant ways since the Microsoft case. And I think the law may have changed in ways that will be to Google's benefit.
So what exactly, Keith, does the government have to prove here, given some of those changes in law, in order for the DOJ to prevail?
Well, this is a monopolization case, a Section 2 monopolization case, Section 2 of the Sherman Act, which means that Google has taken steps that are considered exclusionary and unreasonably exclusionary to avoid having to deal with competitors. And some of those acts involve its contracts. For example, its contract with Apple, making the Google browser the default search engine. So the government will have to show that those actions were again, I use the term unreasonably exclusionary. They excluded rivals in a way that can't be explained by legitimate competition. And so that's going to be the difficulty, the charge in front of the DOJ. Now, I think you did ask, how has the law changed? Well, one of the major ways in which the law has changed since the Microsoft decision is that the Supreme Court had a decision later that came out called Trinko, Trinko, Verizon versus Trinko, in which the court said that a firm with a dominant position does not have a duty to accommodate a rival, doesn't have a duty to take steps to make it easier for a rival firm to compete against it. And so I think, if I were Google, I think I would certainly be asserting that case is a major part of my defense, since that case wasn't available to Google at the time of the Microsoft decision.